appeal in the matter of Imam and London Borough of Croydon, Elkundi and Birmingham City Council.
Yes, Mr Steyn.
Yes, may it please the court. I, together with Mr Manning, Miss Kafaki and Miss Heath, are here for Birmingham in the Birmingham appeal, and the respondents are represented by Mr Narby and Mr Marcus. In the Croydon case which follows, the appellant is represented by my learned friend Mr Westgate, who's here behind me. His junior, Miss Steinhardt, can't be here today but will be here tomorrow. And Mr Rutledge for Croydon is at the end of the row. My Lord, if I may, I shall proceed upon the basis that everything that could have been read has been read.
Well, I think everything on your reading list has been read.
I'm much obliged, my Lord. And I shall proceed in this way, if I may. I shall identify 6 submissions straight away, and then I will develop each of those in a way which I trust is complementary to, but not a recital of, the skeleton arguments that we have put forward. And these 6 submissions are as follows.
Do you want us to take these at dictation speed?
Well, my lords...
well, there's no point giving us six submissions unless we write them down.
I shall take it quite slowly, therefore, so that your lordships can make a note of it. And I shall also, at the same time, give your lordships the reference to the paragraphs in our skeleton, which bears upon the point being made. The first is this, that section 1932 means what it says, that Mrs Justice Steyn misunderstood it, that the proper statutory interpretation produces a meaning that allows for time to meet its terms. And that is paragraphs 7 to 28 of our skeleton, page numbers 21 to 26. The second submission is this, that case law properly understood either supports or compels the interpretation we place on section 1932, and it most certainly does not undermine it. And that is paragraphs 29, 48, pages 26 to 30 of the first bundle. Third, that the planned move list is no more than a list sensibly compiled to assist the City Council in its management of housing, which management is a matter for the local housing authority. And that is paragraphs 49 to 59, pages 30 to 59.
Well, what are we on there, ground 2?
Yes, that would be ground 2. I think it's subdivided, but it's the planned moved list.
Quite how all the grounds fit together and how they fit with the original pleaded grounds in the claim form is a bit of a puzzle, but let's have your 6 submissions first.
Thank you, my lord. Fourth, that the mandatory orders made by Mrs Justice Steyn in any event intruded on the management.
You say mandatory orders, plural?
Yes, I did. I should have said mandatory order because it was contemplated by her plainly that there would be 2, but then one, so to speak, fell away. But the same point obtains that it intrudes on the management by the local housing authority of its housing, and were, quite apart from that point, an erroneous and unwarranted way to proceed. And that is paragraph 60 to 70, pages 33 to 35.
Just while we're on that, one purely factual question: was the mandatory order stayed?
No.
So has it been complied with?
Yes, an attempt has been. Yes, an attempt was made to comply with it, and the matter is now within the county court review system.
So I see an offer was made, but was not accepted.
That's correct, yes. Yes, my lord.
Thank you. 5.
The 5, the doctrine of functus officio has no place in the management regime with which we're concerned, which touches upon suitability. And the learned judge was wrong to hold that accommodation considered unsuitable on one date could not subsequently be considered suitable. And that is paragraphs 71 to 81 of our skeleton. 6, that it was an error to place on one side, in effect, the evidence of the local housing authority so as to hold that the 4th respondent had not waived his right to temporary accommodation. We say that the judge departed from the proper legal approach, and that is paragraphs 82 to 94, pages 38 to 41.
You haven't attempted to relate that to your grounds of appeal, but that will become clear as we go through.
My lord, yes. And I hope that identifying those 6 aspects provides a convenient signpost, if you like, for how I now propose to proceed in connection with this matter.
There doesn't appear to be you don't appear to be intending to deal with the respondent's notice.
Well, my lord, what I will do, if I may, is pick that up as I go along, insofar as is necessary. But I'm conscious, as far as these matters are concerned, of trying to adhere to the timetabled arrangements.
Yes, I mean, I'm bound to say, although it looks formidable and there's a formidable judgment, subject possibly to the respondent's notice point, some of these points are in truth quite narrow, and we don't necessarily think this appeal should last the whole of 2 days. But let's see how we go. Well,
my lord, as your lordships know, I'm, so to speak, programmed for today, but as I've said to my learned friend, and I'll say frankly to the court, I trust that the court wouldn't condemn me if I took less than.
You are dead right about that.
I rather thought I was right in that.
This is very fair. You always get brownie points for coming in under your estimate, and I think this is a case where it's realistic to think that you might. But to come back for the respondent's notice, you say you're picking up as you go along. They are conceptually rather different points. Different. I don't want to hold this up now. I just put my reading of respondent's notice is that we might have to get into the facts in a way that we probably won't have to for your 6 points.
That's undoubtedly correct, and because my approach on those 6 points doesn't require your lordships to delve deeply into any of the facts, as a matter of fact. But can I leave that over for the moment?
Yes. Well, I was just flagging it. Let's get on. Yeah.
because the first matter is the question of statutory
Yes.
interpretation, which may be supposed to be, in fact, the most important matter that arises as far as this case is concerned. And I readily accept, as is pointed out, that a section in an act seeks to deal with a particular topic and to that extent stands alone. But, as is clear, interpretation is always a contextual matter, having regard, amongst other things, to the legislation with which one's concerned. And our principal concern, my lords, is with section 193, but your lordships should note a number of matters in connection with it. First, that those provisions in the 1996 Act touching upon homelessness were to a large extent reenactment of provisions in the 1985 Housing Act. That the predecessor provision, second, the predecessor provision to 1932 was 65(2) in the Housing Act, which in turn replaced section 4(5) of the 1977 Housing Homeless Persons Act.
Sorry, section what?
4(5), section 4, subsection 5.
All right.
Third, that the housing legislation, and I put that quite broadly if I may, clearly provides an important context for the interpretation of section 193. And your lordships may have observed that in at least the long title of the Housing Act 1985, the Housing Acts are referred to collectively. There's no definition, statutory definition of those acts, as there is in the case of planning acts and so forth. But we can be sure, I respectfully suggest, that Parliament, when enacting the 1996 Act, was not doing this in a divorced way from the balance of the housing legislation.
Was it a consolidating act?
The 1985
No,
Act,
the 1996 act.
the 1996 Act wasn't expressed as a consolidating act. Now, your lordships will have seen in the core bundle at page 52, the first volume of the core bundle, the order that was made, which in theory, of course, binds only Birmingham, but in practice is universal to local housing authorities in England. Now, my lord, as far as local housing authorities in England are concerned, there are over 300 such authorities. 309 is the precise figure. Local housing authorities...
So just from my note, you were starting with, this isn't just about section 193, and you were making, I got up to 3 points. Is this a fourth point under that heading?
Yes, this steps aside from that. It's not,
Yes,
so to
okay.
speak, a fourth point, but
No,
it
okay.
steps aside.
No, fine. Yes, it's the...
And because I'm...
How many authorities do you say?
309, in fact, local housing authorities.
Yeah.
And they're defined in this way. Section 230 of the 1996 Act says the definition of them is given by section 1 of the 1985 Act, which gives the definition for the purposes of England as districts, every single district, the London Borough Councils, 32 of those, the City of London, and the Council of the Isles of Scilly. And so the population range in terms of the local housing authorities will be between Birmingham at one extreme and the Isles of Scilly, which has got a population of some 2,000 at the other, but is fully constituted as a local housing authority. Now, my lord, all those authorities have these particular functions under the Housing Act 1985, which we respectfully say are important to have in mind. And the reason why I say that is because it is important to our case to appreciate that the management of housing by such authorities is both a complicated and difficult exercise, but also something which has been expressly entrusted to such authorities by Parliament. And my Lord, if your Lordships take the first bundle of authorities, your Lordships will see that the Housing Act 1985 is behind flag 4, or at least extracts from it are behind flag 4. Which starts at page 22 with the long title to the 1985 Act. And then if one moves on to page 27, by which time one will have got past the definition of housing authorities, which I've given, one arrives at the fact that housing authorities, page 27, section 8, have to consider, under the heading of periodical review of housing needs, every such authority has got to consider housing conditions in their district and the needs of the district with respect to the provision of further housing accommodation. And subsection 2 requires a review of information brought to their notice. Your Lordships will find, passing over a few pages to page 30, that at section 9 one has the ability but not the obligation under the Housing Act to provide housing accommodation. They may provide it. I don't need to read the balance of subsection 1, and then powers are given about alteration and so forth. Powers can be exercised in relation to land acquired for the purpose. And subsection 5, nothing is in the Act is to be taken to require a local housing authority itself to acquire or hold any houses or other land for the purposes of this part.
Section 9.4 is a collector's item.
Yes, my lord, it is, and it is plainly there to ensure that one's not, so to speak, wasteful of land.
You could provide a house with a garden more than 1 acre.
Yes. Well, yes, I suspect, my lord, and I don't know that one needs to enter into a great debate about the particular matter, but cottage, I suspect, has a slightly extended meaning and would embrace what otherwise we might describe as a house. And your lordship will no doubt recollect how cottage accommodation, that expression used to be used in a far broader sense than one understands cottages now. But, my lord, that's rather by the by, if I may say so, and if I could invite your lordships to look on, one will see that, and I'm not sure whether your lordships have section 14, it doesn't matter, it's been handed in, but that enables functions to be performed outside the district. Section...
Hang on, let's just see what we have, rather as written in my book. We've been handed section 27 and section 14, yes, I see. Okay, so we'll just put it in now.
I suspect that's the easiest thing.
Okay, yeah.
I don't need to trouble your lordships with the terms, but your lordships will see that enables steps to be taken outside the district. Section 17 enables acquisition of land for housing purposes, page 34. And section 18, page 37, imposes a duty with respect to buildings acquired for housing purposes. And there's quite interesting language in section 18, subsection 1, where the authority acquire a building which may be made suitable as a house, they shall forthwith proceed to secure that the building is so made suitable, either by themselves executing any necessary works or by leasing it or selling it to some person. Don't read on. And so Parliament, when it wants something done forthwith, inserts such a provision. Section 20 application of housing management provisions, page 40. The following provisions apply in relation to all houses held by a housing authority for housing purposes. And then section 21, which is an important provision, which I'd ask your lordships particularly to note. General powers of management. The general management, regulation and control of a local housing authority's houses is vested in and shall be exercised by the authority, and the houses are at all time open to inspection by the authority. And then your lordship will you'll also have section 27, which I think has been put forward, and section 32, which I'm not sure is in the bundle, but enables, page 44 it is, enables property to be disposed of by a local housing authority. Now, my lord, pausing there, if I may, it's of some significance the provision to which I've drawn attention about vesting in and exercised by the authority. And your lordships will note or have seen that the royal assent...
Why is it of significance?
Because of a case I'm about to show your lordships called Parker.
Okay.
Your lordships will have noticed that the royal assent for the Housing Act was given on October the 30th, 1985, and the case to which I'm about to refer was decided prior to that, so that Parliament would have had, so to speak, notice of it. The case of Parker, my lord, is good for this proposition that if management is in the hands of the local housing authority, it cannot be taken away and cannot be taken, so to speak, over by the courts.
Well,
now,
that's obvious, isn't it?
Well, my lord, it required a decision of the Court of Appeal, so to say, and I would like to show it to you, if I may. It's called Parker and Camden. It's volume 19. It's tab 19, I beg your pardon, and 230 in the bundle.
Sorry, my authorities bundle isn't marked up with which tabs are in which bundle.
Oh, I
so
beg your pardon.
You need to say which
Page number.
No, you need to say which bundle number.
Oh, bundle 1.
For those who are putting bundles together, always remember that. If you put on the back, I mean, I can do it for myself over lunch, which tabs are in which, then we can find them more quickly. Yeah.
My Lord, Parker was a decision of the Court of Appeal presided over by the then Master of the Rolls, Sir John Donaldson, and decided in March 1985. And it concerned a situation of some seriousness because there was a problem in consequence of a strike which had happened, causing no heating to be given to a large number of estates. And if your lordships look, please, at page 234, against the letter F, your lordships will see the argument that was put forward about local authorities having been specifically entrusted by Parliament with management of property and many other functions relating. Section 111 is then recited, which is the equivalent of the section I've shown your lordship. No power to transfer this obligation to anyone else, whether he be a receiver or not. The plaintiffs wanted to appoint a receiver. This is a matter of jurisdiction and not discretion.
But why does this help us?
Yeah, it's a very different set of circumstances. They wanted to take over and give to somebody else the job of running the heating system. The question here is where Parliament is given the general power for management and impose specific duties in relation to the homeless. What is the scope of those duties? And that's a different question.
You just want to make a debating point that the courts shouldn't make life difficult for the local housing authorities in exercising their statutory obligations, and I quite see that point. But you don't. It's a point best made in one sentence, and you don't make it any better by referring to an authority on a different point.
Well, my lord, in my respectful submission, the point is not, if I can put it this way, that different, because if your lordships look at page 241 as...
Well, you can't take a hint, Mr.
Well, my lord...
All right, we'll look at it.
Yeah. The 241, and what Sir John Donaldson has to say... When Parliament expressly confers powers and imposes duties and responsibilities of an important kind upon a particular body, it is, as he put it, improper for the court by the appointment of a manager. Now, I readily accept the observation which is put at me, namely that here no one is asking, please may we have a manager of the Birmingham properties. But what is being done in effect is the same or similar to that which is the matter of consideration there.
No, it's not. It's nothing like it. If a mandatory order is made telling you to comply with your duty, that's something, if you've broken your duty, it's simply telling you to do what Parliament told you to do. So what's the problem?
Well, my lord, the matter would refer to and relate to the question of, so how would one interpret that particular duty which is cast upon the
Yes, I understand
authority.
that, of course, but if the duty exists, the courts have got to be able to tell you when you're in breach of it. You can't say, oh, well, none of your business because Parliament told us to manage the property, manage our housing stock. This isn't a helpful point, really.
Well, my lord, Lord Justice Brown Wilkinson at page 176, I just mentioned, ran alongside, so to speak, Sir John Donaldson. But my lord, the reason why I would respectfully say that it is of assistance is because if the position is one whereby when you have functions which are specifically entrusted to authorities and they are not to be, so to speak, interfered with by others, including the courts, then that must bear upon, I respectfully suggest, how one interprets the duty which is imposed, because, to go to my lord's observation, if the duty is a duty to secure, so to speak, accommodation over time, then one can see how that can be satisfied. But if the duty is you must provide accommodation today or tomorrow, then as soon as one steps into that and says the courts can do that, one is stepping right into the question of the management of the housing, of the local housing authority. That's how I would respectfully draw attention to and rely upon Parker in this particular matter. My lord, the section 1932 derived from Section 65(2) of the Housing Act, as I've just indicated. And although the language of Section 1932 does not precisely reflect the language of Section 65(2) or its predecessor in the 1977 Act, no one suggests that any material change was made. And furthermore, Lord Hope, in a case we'll come to look at, called Ali, said that the provision was exactly the same in Scotland, where the language reflects the earlier language used in our housing legislation. Now, my lord, that housing legislation touching upon homelessness was, of course, enacted first in 1977, leading to the provision that I've mentioned. And your lordships will know that it came to be considered, famously in the case of Pulhofer, which your lordships will see at flag 20 in the bundle of authorities. Volume 1.
Thank you very much.
Beg your pardon.
No, you did well, Mr Fraser. Thank you.
Now, the precise consequence in terms of accommodation and whether one attributed any qualifier to accommodation was dealt with by legislation. But your lordships will know that Lord Brightman gave an important speech in connection with this legislation, which bear upon this whole exercise. And if you could go to page 282 of the volume of authorities, bottom right, volume 1, which is page 517 of the report, the appeal cases, where Lord Brightman draws to the attention of the House several features, letter B, of the Act, which in his opinion had to be borne in mind. It's not an Act which imposes any duty upon a local authority to house the homeless. As the long title indicates...
If this is a long passage, should we read it to ourselves, or is it just a few phrases?
It's really a few phrases, my lord, if I may.
Yes, of course.
It's not an Act imposing any duty. Long title indicates makes further provision. Act to assist persons who are homeless. Act which only came into operation in England and Wales only 4 months and in Scotland only 7 months after it was passed. Not sufficient time to enable a dramatic increase in stock. Intended to be a lifeline of last resort, not to enable them to make inroads into the local authorities' waiting list. Now, my lord, just if one pauses there for a moment, that was so stated by Lord Brightman in Pulhofer about the 77 Act, and the situation appears to be worse today than it was then in terms of housing, and indeed when we look at the Ali case and the speech or judgment of Baroness Hale, that is made plain. Now, my lord, we can then, if I may respectfully say so, stay in the same volume of authorities, but go back to flag 2, where one notices the Interpretation Act 1978 with the implication on the imposition of a duty that absent a contrary intention, and no such contrary intention here appears, the duty is to be performed from time to time as occasion requires. My Lord, this provision hasn't seemingly in the cases in the various bundles of authorities been referred to before, and I suggest it is of some importance as far as this matter is concerned, because what it signifies, in my respectful submission, is that from time to time, given the implication of what is said here, the local authority should, as occasion requires, secure that accommodation is available for occupation.
How does it help?
Nothing to do with this. Sorry.
I mean, how does it help here? I mean, if he's got a duty on Monday, the 1st of March, to do something, and the same or different circumstances arises on the 10th of March, they've got to do it. But how does it help you work out what the duty is on the 1st of March?
Well, my Lord, the position is exposed by your Lordship's question as to the importance of distinguishing between the identification of the duty, which one can see from the terms of the legislation, and the question of the performance of the duty. And that is a critical matter, because one can look at that in different aspects as far as this case is concerned, because one has the question of the commencement of the duty, and one can identify the commencement of the duty, but that is different from the question as to the commencement of the accommodation.
Well, that may be so, but that's not quite the point you're making. I can't see any distinction. As soon as there's a commencement of the duty, there's a commencement of the duty to perform the duty. I don't see how you can distinguish between the two. The duty is to do what the Act says you must do, and as soon as it commences, you've got to do it. The question in this case is, what is it you've got to do, and within what time frame?
Yeah,
this Section 12 doesn't help on this at all.
Well, my Lord, I would respectfully suggest that it does, because when one looks once again at the terms of it, the duty is to be performed from time to time as occasion requires. Now, I readily accept, as my answers to your Lordships have indicated, that the position is one whereby one can identify the time when the duty obtains and comes into existence, but its performance from time to time as occasion requires. One can interpose this question, and properly do so. Does that signify that is to be performed from time to time as occasion reasonably requires, or the occasion unreasonably requires? Because that's the contrast between the two situations which exist, with the judge saying this is something which is immediate, unqualified, and you just have to do it and do it now.
There is a difference possibly, Mr Straker, between the duty arising. The duty arises once the conditions are met.
Yes.
And the question is to what constitutes sufficient discharge or performance of it. And that may change over time, because it may be they're in temporary accommodation and it may be suitable to let them stay there for a little while longer and so on. So the performance or the acts necessary to discharge the duty may change over time, but it doesn't mean the duty is being performed differently in the sense that there's a new duty arising and being exercised. The key thing is to look at when does the duty arise and how is it discharged?
Yes, but one also can ask, and it's, I would suggest, implicit in your Lordship's observation, what constitutes a performance of the duty?
Because that's what 193 requires. Section 12 is all about a different thing, when the duty is performed on a second occasion. Here there's one duty, it's being performed over time, arguably in different ways. It just doesn't help.
Well, my Lord, the duty here under Section 1932 is a duty which arises, and one can, as we've said, identify that moment. And the duty then, as both the legislation and the cases indicate, is something which persists for a period of time. And it persists for a period of time during which, of course, the question of performance arises. And the difference between the parties is this question of immediacy, where we say, well, we can perform this duty from time to time as occasion requires, or leaving that language.
The occasion requires all the time, that's the point. As soon as the duty exists, the occasion requires, and the occasion goes on requiring until the duty is complied with. The Section 12 is concerned with a completely different situation, where you've got a duty which may arise for a bit, and then stop, and then arise again. The 1978 Act covers, I'm sure you'll find this in the original interpretation, Act covers all sorts of different situations. There's no reason whatever to suppose it had this sort of situation in mind at all. Indeed, logically, it didn't.
Well, my lord,
why don't we look at Section 193 and what it says?
Well, my lord, we're about to do that, but my lord, as far as this is concerned, I mean, Section 12, this is perfectly general in terms of what is implied into a duty.
Yeah, well, all right, but it doesn't have any bearing on this situation, because you're not suggesting the duty doesn't arise from the moment the conditions in Section 193(1) are present. It's no part of your case the duty doesn't arise. The question is what you have to do to comply with it.
Yes, and the performance of it to be performed, that duty is to be performed from time to time as occasion requires.
Well, you're not making much headway with me, but
well, my lord, I've made that particular point in terms of how that operates, and in my respectful submission, it does actually help us in connection with this particular matter, because it shows the significance of the question of time in relation to performance. And as I say, I also say that one wouldn't expect an occasion to be demanded which was unreasonable rather than reasonable. But my lord, Section 193(2), you have in the authorities bundle at Volume 1, Flag 7, page 96. And the relevant words are right at the foot of the page. They shall secure that accommodation is available for occupation by the applicant. They being the local housing authority in question.
You've got to start with Section 1. The section applies where certain things exist. And once certain things exist, then the duty applies.
Yeah, subject to the proviso about reference. That's absolutely right, but the critical words as far as this case are concerned are those words after the comma in subsection 2, my lord, as to what has to be secured. They shall secure that accommodation is available for occupation by the applicant.
The duty has arisen once the conditions in 1931 are satisfied. Do you agree with that?
Yes,
Once the authority says they're satisfied of A, B and C, then the duty is owed.
Yes, the duty is owed, and the question then arises as to what is constituted by and what has to be done in order to perform that duty. That's what the argument is all about. And the words which bear upon that in the final analysis are those words after the proviso in subsection 2, they shall secure that accommodation is available for occupation by the applicant. And I respectfully say that language and that obligation is quite plainly an obligation in futurity. They shall secure that something is available, and the obligation is to secure something which has to come to be secured and which need not be secured, if I put it this way, on day one. Because what the authority are required to do, what their duty is, to do something which I say is clearly in futurity, shall secure that something is available for occupation or becomes available for occupation, which was the language used in Scotland still and previously in the legislation with which we're concerned.
Sorry, what was the language used in Scotland?
Becomes available for occupation.
So it becomes rather than is.
Yes.
Yeah,
But
okay.
section 4.5 becomes as
Yeah,
well.
absolutely. 4.5 in the Housing Act were becomes, and then it became this. No one, as I've indicated, suggested that brought about a change in the law, and Lord Hope drew express attention to that in a case which we'll have to come to. Now, I respectfully say that if something is to be secured, or someone is required to secure something, you are necessarily allowing a period of time which must be reasonable, for it could not be an unreasonable time. And this is where it is so important to have in mind the distinction between the commencement of the duty and the commencement of the accommodation, or the commencement of the fulfilment of the duty. And if one looks at section 206 of the 1996 Act, at page 118 in volume 1 of the authorities, still behind flag 7, your lordships will see that local housing authorities are told that they can discharge their housing functions only in the following ways, A, B, and C: by securing that suitable accommodation provided by them is available, by securing that he obtains suitable accommodation from some other person, by giving him some such advice and assistance as will secure that suitable accommodation is available from some other person. And we respectfully draw attention to those aspects of section 206 and the fulfilment, how they discharge their functions. Each method seeks the same end. Each method necessarily involves the passage of time. And each method, in its performance, demands or requires a reasonable time.
Well, just pausing there, actually, we can look at section 188 in a moment. Say that this person or this family has got no accommodation. It is not a case of there is one property which must be suitable for the long term. If they've got nothing, why is the duty not requiring you at least to provide, for example, bed and breakfast accommodation for a couple of nights, and that will be suitable in the circumstances, because they are homeless, they've got priority need, it's not their fault, they've got nowhere to go. In the longer term, they will either have to be given accommodation by the authority or by advice and assistance to get it. But you can't leave them without anything. And in fact, after section 188, they probably will be in temporary accommodation. So it is not really the case of this duty requires them to have a complete house fully fitted out at the same time. There's got to be something that can be suitable accommodation, and the way in which it pans out over time will depend on circumstances.
Well, my lord, that's correct. I mean, in the circumstance of someone presenting himself, meeting all the criteria for provision under 193, who literally has absolutely nothing over his head. It's all been blown away in a storm or whatever it may be. Then the position is one whereby what happens, and what would happen in Birmingham, is that some sort of provision is made. Now, what that provision would be, I couldn't tell your lordships. I suspect it wouldn't be the most comfortable in the world.
But it would be something that was suitable in the circumstances. So the duty, the performance isn't a one-off, perfect house immediately suitable for 7 people. It may be something that fits the necessity. If you look at section 188, they will in fact have been provided with something. And when the duty arises, arguably under 192, the question is, well, they've got temporary accommodation, how long should that be regarded as suitable for? It's not a case of there being no obligation to do anything. It's what is appropriate may differ and change over time.
My lord, I don't dissent, I suspect, from any of what your lordship has said. There's plainly a multitude of different circumstances which can arise, and we've contemplated one extreme circumstance, the man who has his house blown down. The multitude of other circumstances don't repeat that particular situation, but tend to derive from the characteristics of the accommodation which is occupied.
Yes, but isn't the answer then that in such a case you say the duty arises there and then to provide suitable accommodation, not to provide suitable accommodation when you feel like it, or when you, no, sorry, that's an unkind way of putting it, but suitable accommodation in due course. Duty arises then, but the property in question will be suitable for the time being. That's a better way, surely, of analysing the problem that local authorities have. Not saying the duty doesn't require to be performed for a bit. The duty requires to be performed at once, but what it takes to perform it will depend on the circumstances, so that the property which is will not be suitable in the long term will be suitable in the short term. The difficulty in this case is that you acknowledged from the start that the property they were in was unsuitable, and you then said, well, it's not quite what we meant, but the judge found against you on that, and there isn't any appeal. In other words, what I'm putting to you is that the problem, which, speaking for myself, I absolutely fully understand, is addressed by saying that the property about which complaint is made isn't suitable, is suitable for the time being, but not in the longer term, rather than saying we agree now it isn't suitable and we'll do something about it when we can. You see the distinction I'm putting to you?
I readily see the distinction that your lordship is making, and your lordship will have also noticed in many of the cases, or some of the cases, a reference to a staged approach being followed, the passage of time, as far as 193 is concerned. The staged approach reflecting, if I may pick up on my Lord Justice Lewis's man whose house is blown away, the situation where first something is done as far as that is concerned to enable him to be covered from the elements overnight, and then something else is done. It's all performance of the duty, the 193 duty, and it all is premised, I would say, actually, upon a reasonable time being provided for the performance of the duty, because if that question is related to the circumstances that obtain, not merely bearing upon the individual who's had his house blown down, but also bearing upon the housing authority where one happens to be and its difficulties or its largesse, the situation is one whereby one says to oneself, how does one perform this duty? Answer, one performs this duty by providing for a reasonable time in order to achieve the ends which are sought.
Well, that's really restating your case. It's not meeting my point about it. Why isn't a better analysis, not that you take a reasonable time to perform the duty, but you have to perform the duty straight away, but what it takes to perform the duty in the short term may be different from what it takes to perform the duty in the long term. In other words, a property may be suitable in the short term, but not suitable in the long term. And my Lord's example of the person who is literally on the street and is put into very unsatisfactory accommodation for a day or two, you don't say in that situation, well, we're not performing the duty for the time being, but we will as soon as we can. You say, no, I am performing the duty now by putting you into bed and breakfast, and it is suitable now as a short-term measure. i.e. you load it all into the concept of suitability, not into the concept of not having to perform the duty for the time being.
Yes, but that runs, I would respectfully suggest, into the difficulty that obtains, and particularly obtains in an area such as Birmingham, where you may have the situation whereby, with the best will in the world, you have people who are in accommodation which can be said to be unsuitable for them because of. You can then say, my lords, we're not going actually to identify it and categorise it in that sort of way because we want to, forgive me for putting it like this, fudge on the duty side of things, and we're going to do to say that is therefore the duty being performed. Rather more sensible, I suggest, is to be able to say this is a duty which stands to be performed after a reasonable time or in a reasonable time, with a reasonable time obviously varying according to the circumstances, but those circumstances providing for the situation whereby somebody may be in accommodation which one would otherwise categorise as unsuitable, but there is literally nowhere where the local housing authority can place that person other than to say, look, I'm very sorry, you've got to stay there for a while, and we're going to make sure that we manage our properties, keep an eye out and so forth, and to see what comes forward. And we will return to you as and when we can, but we're not going to go about unperforming our duty. We're going to continue to perform our duty. It's just that a reasonable time requires that circumstance, because if one extends...
Could I just, just interrupt you? Sorry. I understand why in this case you're keen on the idea of a reasonable time because of the judge's findings in relation to what you conceded. But the distinction that you're addressing at the moment arising from my Lord's question seems to me perhaps to be the difference between in a reasonable time or in a reasonable way. That's what is in question here. Now, before you, if you wish to answer that, we go back to section 193. It seems to me that the sort of difficulties that understandably arise for an authority in your position may arise because it can be satisfied by a very wide range of candidates. That in some cases, the man whose house blows down seems to be absolutely what Parliament first and foremost will have had in mind. The sort of emergency case where something's got to be done, it's got to be done quickly. But it also covers, by I think a web of statutory definition, people who are housed for a long period of time, who have had a roof over their head, unfortunately, for years, which has not been, strictly speaking, suitable, but nevertheless is a million miles away from somebody who's street homeless. And so I just wonder whether it's potentially a fruitful line of argument on your side that the multiplicity and variety of people who can be helped by 193 speaks for giving it a broad interpretation of the kind, whether it's the one that you contend for in a reasonable time or the one that my Lord mentions, which it seems to me to be in a reasonable way. And that simply saying for all of these people that it's, that's, you know, you have no time at all to perform this duty, housing now, and suitable housing now, because it's got to be suitable, really is not what Parliament could have intended, and that what is suitable has got to be read in the context of the type of need that is presented. But that still leaves you, I accept, the difficulty that the judge found against you as to what your letters meant.
Yes, my lord. But I would respectfully, if I may do so, respectfully adopt the suggestion that the question of reasonable time can be used as a kind of touchstone for performance in a reasonable way. And that is plainly something which is, I would say, inherent in the legislative scheme and also inherent in actually the circumstances that can be envisaged whether one takes the solitary house which is blown down or the circumstance whereby an entire village is rendered uninhabitable by virtue of some catastrophe, flood or whatever it may be, where one would have a very different circumstance from the individual, and in circumstances where one's saying, well, now this large village which has been treated in this catastrophic way, and what are we going to do? And how are we going to do our section 1932 duty in connection with that? And I would respectfully say that the answer would be that one says this is a duty to be performed in a reasonable way, and the reasonable way embraces also the circumstance of time. And that then takes one directly back to the sort of illustration that your Lordship was giving, rather more than an illustration, because it reflects the facts in very many cases of people who have got roofs over their heads unsatisfactory. It may be that it's not reasonable for them to continue to reside there, and there's a slightly different concept in the legislation between reasonable to continue to occupy and suitability. But one's confronted by the difficulty which confronts Birmingham of thousands of such people and hundreds of houses. And therein lies the difficulty on a practical basis, which can inform the interpretation of these provisions, especially when one bears in mind what Lord Brightman had to say in Pulhofer about how nothing special was done for local housing authorities before this was introduced. There was no largesse from Parliament or the Chancellor to houses or time to enable these things to be done. And therefore, it has to be an exercise in what is performance reasonably, and that's how matters there rest. Now, there's a difficulty in all this which one must acknowledge, in the sense of it may be thought to appear that a number of different techniques have been used to overcome the kind of problem that has just been canvassed, where one sees in the cases Court of Appeal and High Court saying, well, this is obviously something which is done in stages, and stage number 1 might not be very satisfactory, and it gets better as you go along. You have that aspect. And then you have the aspect of saying, well, let's think about suitability and apply a temporal concept to suitability. It's okay for you to be there for a period
Sorry
of
to
time.
interrupt your train of thought, but quite an important point for me. I'm sure my lords are already there. Where does the concept of suitability actually come from? I dropped back to a section 175 and then 177. But
Well,
where's the actual?
if you go to 206, my lord, in the Act,
It's how you discharge.
you discharge the function.
The only way you can discharge it is.
Sorry,
Yeah.
you're quite right. When we looked at that, I wasn't.
And
So,
then,
okay. No, you've answered my question. No need to.
Mr. Again, on the question of the statute, can I just check the structure? Section 184 says you've got to carry out an inquiry into cases of homelessness or threatened homelessness to see whether any duties are owed. And it's really section 188 I wanted to ask about. That's the interim duty. It's at page 90. If the local authority have reason to believe that an applicant may be homeless, eligible for assistance and have a priority need, so they have a pregnant woman in front of them that says, my partner's kicked me out, I've got nowhere to go, the authority must secure that accommodation is available for the applicant's occupation, which is similar in wording but not identical to 1932. Does that have the same, must secure that accommodation is available within a reasonable period of time at the interim stage, so that they can decide, well, it'll take us a few weeks, the pregnant woman, will just have to sleep on the street for a few weeks, and then we'll come back to you. Is it the same analysis, or do those words mean something different for 188 as compared to 193?
no, the words don't mean, I would respectfully suggest, anything different. But one has to be careful, if I may put it this way, about the illustrations one uses, because the pregnant lady on the street may elicit, in terms of reasonable time or reasonable response, a different answer from the circumstance of the situation where a group of people have got a roof over their heads, or when one responds differently in consequence of the situation. In other words, one can't reason, so to speak, from the particular to the general here. The position has to be one whereby one must bear in mind that one is covering a huge range of circumstances with very limited resources on the part of the local housing authorities, and therefore the position has to be touched, I say, by that question of reasonableness.
But it's still a duty to secure accommodations available within a reasonable time, but what may be reasonable will differ on whether you've got a pregnant woman, a man with mental health problems, whether they're homeless because they literally are on the street, or whether the partner has said, you're out tomorrow or you're out in 7 days. So it's the same conceptual duty within a reasonable time, but the circumstance of the individual may affect what constitutes reasonable time.
Yeah, absolutely, my lord, absolutely right. And the circumstances not merely affecting the individual, but also affecting the local housing authority, because you can't divorce the one from the other, because if the local housing authority has, whether through no fault of its own or otherwise, inherited a situation whereby it is profoundly short of accommodation, then that bears upon how one reasonably responds to a given circumstance.
That's why you very often have to put people in bed and breakfast.
Yeah, that's.
But you say there's no duty to do that. There's no duty to do anything immediately, even if it's a mental health person or a...
No, my lord, I wouldn't respectfully say that Birmingham would put the matter like that. Birmingham recognise that provided the requirements of 1931 are met, then the duty obtains. And then the question is one of performance, and performance will vary from circumstance to circumstance, and what is reasonable is capable of varying from circumstance to circumstance, because this is not a one-size-fits-all, because we're dealing with the population at large.
But it is a duty to secure within a reasonable time. It's just the question of what's reasonable differs, as I understand it.
Yeah, absolutely, my lord. And as far as that is concerned, we would add to that the question of what is a reasonable time is, I don't say, if I may, because I've been caught out before in putting in absolute terms, but generally speaking, would be a matter for the local housing authority, because the local housing authority, as we've seen, is charged with knowing what's going on.
You're putting an open door there. I mean, if it's within a reasonable time,
Yeah.
then the court can only review it if it's unreasonable. And reasonableness, as we all know, has a range of, has a spectrum. So I don't think you need
Well,
bang on that drum.
Could you help me just with the structure of these provisions under Part 7? One of the conditions under 1931 is that the 189B2 duty has come to an end. So are we? Is the duty under 198, which we've just been considering?
198.
188.
188.
I misspoke. And 189B. Are those the provisions that cover the man whose house is blown down, the emergency situation, and provide for an interim solution? And so one is only considering under 1932 more medium-term or long-term circumstances. I'm just wondering whether the juxtaposition between the applicants in this case and the emergency street homeless is not an exact juxtaposition, because the latter would go through 188 and 189B before arriving at 193. Could you put me straight on how this works?
Well, I suspect I can put you straight, I hope I can put you straight in this way, that the legislation provides a sequenced approach.
Yes.
And that sequenced approach means that one has the circumstance of the interim duty which can arise under 188, and one has then 189B.
Sorry, can we just take this slowly?
Yes.
Because it's important to me. So, interim duty under 188, and the test is, as it were, the full test: homeless, eligible, and priority need. But the difference is that it's not yet been established that they satisfy that test. It's a reason to believe.
In other words,
And then
this might be the case, but we don't yet know.
No, quite. And that's what you have a duty to investigate. And in theory, the investigation could take a very short time, though in practice it doesn't.
It varies.
Yes. So then I don't understand, and I'm grateful to my Lord for drawing attention to it, how that duty under 1881 relates to the duty under 189B. But the initial difference is that for 189B, it's not a question of satisfaction, as it's a question of being satisfied, so it's not a question of reason to believe. So that's one difference.
But it's satisfied.
And the other difference is there is no there's no reference to priority need.
That is the big difference, because as your Lordship has observed, the local housing authority has to be satisfied of some things, that is to say the A and the B in 189B, homelessness and eligibility for assistance, and that does not require them to be satisfied about priority need, which is a matter which, when one looks at 1931B.
But hold on, 1894 as well. The duty ends once the authority becomes satisfied that the applicant is a priority need and or not satisfied. So there's an interim duty, if you like, where they're satisfied about homelessness, but once they're satisfied a priority need and are not satisfied the person is homeless intentionally, then it comes to an end 56 days, at the end of 56 days.
Yes.
But this is a sort of different sort of animal, and one can see that by the fact that it was obviously introduced later. The sequenced approach that you were telling us about is to people who have or maybe may have a priority need. And that goes straight from 18881 to 1932. Is that right?
Yes, my lord.
189B doesn't fit into that sequence. That's for people who are in a different track, because there's no question of priority need in those cases. Is that right? And you don't have to give them anything. You simply have to give them reasonable steps, which is a completely different kind of obligation to securing that something happens. Reasonable steps to help the applicant to secure, not must themselves secure. But if that is the right analysis, it seems to me to be, I don't quite see why 189B is referred to at all in 1931C.
So you're not operating under two channels?
Yes. I think the answer goes as follows, or I suggest the answer goes as follows. Section 189B was introduced by the Homelessness Reduction Act, which Act, 2017, as its name suggests, sought to reduce the incidence of homelessness and provide for a form of assistance or prevention from homelessness, as to which 189B provides an example. This section applies where, and so forth, and you do these things. If you've left 189B behind, and you are then within 193 takes over, but you wouldn't want 193 to take over whilst 189B was still, so to speak, in play. And the observation just made about you want to know where you are in this particular regime is, in my respectful submission, an apt observation.
So while you're being helped under the 2017 Act, and the 2017 Act, 193 is not available yet to you, but it will become available to you when you get out of that.
Yes, may become available to you, because it may be, of course, that the assistance provided, or what happens under 189B, is advantageous to the individual, so as to enable that individual to say, I don't need to trouble you further.
It prevents a doubling up of processes.
Yeah.
Yeah. Well, that's very helpful. So we can really ignore 189B then, can't we?
I would have thought one can largely put 189B on one side. It's quite interesting that 189B provides for these periods of time, but that's something of an incidental observation, but we're concerned because of the way this has gone with it.
Can we then go back to my original question, which is whether the reality is that the individual catastrophe event, as it were, is likely to be treated through 188, and one only gets to 193 when one's in a position of more stability?
The answer to that question would be that Section 188, in terms of the catastrophic situation that your Lordship mentioned as a preliminary to the question, would operate so as to secure, well, the local housing authority, we now have reason to believe something awful has happened, and therefore, and that then can move on to, because the reason to believe and the inquiries may harden into satisfaction under 193. So one steps.
So they're not necessarily different in kind, but it may be that the investigation moves from reasonable satisfaction to satisfaction, and on it goes under 193.
Yes.
What's the purpose then of 189B subsection 4? That seems to be saying that there's a 56-day period in any event under 189B, and there's going to be a 56-day period before the 193 duty applies, although you may still get temporary accommodation under 188 once it becomes apparent that you're in priority need. So it looks as if there's going to be a 56-day period when it's either your own attempts or interim accommodation before the final duty applies.
My Lord, yes, and I have to confess that I've spent some time puzzling over that precise provision as to how it slots in and works, and whether or no it provides for a period of time where one might have the 193 duty in place, but one's operating under 189B, and therefore it's apparent that one can have time under 193. My Lord, I would respectfully say that we're not going to get, or your Lordships are not going to get, the conclusive answers needed for 193 out of the way in which 189B proceeds.
But you are to a certain extent, because if 189B gives you 56 days in any event, there isn't going to be the full duty. So Parliament has built in now the 56 days. True it is there might be interim accommodation, because if you appear, or indeed if the authority is satisfied that you have priority need, you've got the duty to do something under section 188. But the full duty is only going to click in 56 days. Because until then, the 189B duty won't have come to an end.
Well, my Lord, as I say, that is precisely the thought process which we considered and consider plays a part here, but I wouldn't wish to submit to your Lordships that your Lordship should determine this particular case on the basis of that.
It's not the point I think I detected in your Stelton argument.
No. It's a matter which has been the subject matter of thought as we've prepared for this hearing.
Right, let's just take stock of where we are. We've been, I think, helpfully exploring what are really the core issues in relation to your first point, before we come to the authorities. And speaking for myself, there may be other things you feel you've got to still say at this stage, but speaking for myself, I'd have thought we need to get to the authorities sooner rather than later.
Well, my Lord, that certainly is coincident with what I would like to do. Good. Can I just ask your Lordships at this stage to note rather than to turn up? Stroud's Judicial Dictionary, flag 78, in the third bundle of authorities, 1209 and 1216, which support the matter of futurity. And can I also ask your Lordships to notice at this stage, but as I say, I don't ask your Lordships to look it up now, the judgment of Mr Justice Moses in Ex parte Anderson, first bundle of authorities, flag 28, page 390, where he deals with, in particular, the section as originally enacted and draws out from that the proposition that time was allowed. But can I, having said those, do what I would wish to do, turn to the cases which are of particular significance.
Yes, just pausing there. It's my view, and I think I speak for my lords, that although there's been a certain amount of first instance decision, including the one of Justice Moses, which you've just referred to, really what's required at this point is some careful analysis of what the ratio of Ali in the, I forget whether it's the Supreme Court or the House of Lords, Supreme Court I think was, no, House of Lords.
I believe it was Supreme Court.
Or whichever it was, don't worry. Therefore also the Court of Appeal there and the Court of Appeal in Cardona, although they do refer to Justice Moses, Justice Collins in other cases, we're not bound by those, whereas we are bound by any ratio we can identify in any of those three sets of decisions.
Yes, and I would add, if I may, the case of Hindi to your Lordship's list.
Well, fine, you take us the ones you want to, but I was just politely discouraging you from taking us to the first instance cases, unless you particularly...
No, my Lord, I'm...
Make one point.
Yes, sir. My Lord has a point before we get
May
there.
I just ask you about one thing before we dive into the cases? Could we go back to the declaration, which is the target of your appeal?
Yes, my Lord.
Page 52 of the full bundle, paragraph 1. I just wanted to spend a moment looking at what the judge actually declared and what it actually means. You've made the point so far that it applies up and down the land.
Yes.
That what is being said is that the duty is immediate, unqualified, non-deferrable to secure suitable accommodation. Now, could we stop there for a moment before reading it all together? Maybe it may be pedantic, it may not be, but it doesn't say in terms that it's a duty to produce suitable accommodation immediately. It refers to an immediate duty.
My Lord, yes, it refers to an immediate duty, but one can't omit the words which then follow.
No, but we'll come to those.
Yeah, okay.
But not a duty to secure the availability within a reasonable period of time. Now, again, at the risk of pedantry, it looks as if the judge was thought that she was mentioning two exclusive alternatives. I'm just wondering whether there is, in fact, on close reading, not an excluded middle, which has crept in that on one reading is not a watertight and exclusive range of possibilities. Of course, a lot depends upon the drafting and how one understands the drafting, and of course, anybody looking at this at a distance would say, "Well, keys now," is what this means. Not we'll start looking later and put you on a list. But I'm not sure that, speaking for myself at the moment, and I raise it now before we go and look at what other courts have said about this general issue, as if that formulation answers all the questions which we've been considering in a watertight fashion. I know it was intended to, but I'm not sure that it does.
Yes. Well, my Lord, of course, all these things are subject to the vagaries of drafting, and it is apparent, I would suggest, that the learned judge thought that she was, on the one hand, X, and on the other hand, Y, and that was the split. And that what one can take out of it is that it is said to be an immediate duty to secure suitable accommodation, with this contrast that you can't do that within a reasonable period of time. So, beyond offering those remarks in respect of your Lordship's observation, and without seeking on my feet to try and discover whether there's an undisclosed middle there.
Well, as lawyers, we always try and avoid just coming out and saying it. But I mean, what the judge didn't come out and say is that the duty under Section 193 is a duty to provide suitable accommodation now.
She didn't say that, but she used the word immediate. Yes.
Yeah, but I thought you weren't. I thought you weren't disagreeing at an earlier stage. You were saying no, the duty arises immediately, but you were saying it does not require the performance. Sorry, it does not require the making available of a property immediately.
Instantaneous provision.
It doesn't require immediacy of action.
You see, I mean, I'm drawing attention to the fact that the duty is immediate, but it isn't, except rather than implicitly from the second half of the sentence, saying that the property has to be produced immediately.
Yes.
And that's what this is all about.
Yes.
But I just, before we looked at what other judges have said about this, I just want to work out what we're really concerned with in the declaration that has been provided, because I'm not sure that if this declaration stands, that it doesn't leave room for this sort of annoying argument to take place on another day.
Yes, and I suspect I wouldn't be alone in saying that one should seek to avoid annoying arguments. But one has the problem with it of the language of immediacy and the contrast of the negative provision put in the final set of words.
Well, thank you for that detour, but should we go to the authorities?
My Lords, I indicated to my Lord that Hendy was a case to be added to the list which was put forward. This is in volume 1 of the authorities at page 224 behind flag 18, and it concerned a family who would, in consequence of a closure order, turned out of a basement unfit for human habitation in circumstances when the relevant act required that they be provided with suitable alternative residential accommodation. And if your lordships get to that flag, your lordships will see that the Court of Appeal was presided over by the Master of the Rolls, Lord Denning, and at page 226 he indicates that that which they'd had to consider, and on the top of the page your lordships will see what the duty was that arose, the duty of the relevant authority to secure he will be provided with such other accommodation, that is to say, when one looks further up, suitable alternative residential.
Sorry, I've got lost.
I beg your pardon, my lord. My fault. I'm on page 226 of the bundle of authorities.
Yes.
Which is the first complete page of Lord Denning's judgment, the second page of the report. And if you look at the top of that page, you are within an extract from the Land Compensation Act, which imposed a duty to secure that he, this is the person who's turned out, would be provided with such other accommodation, and that such other accommodation plainly refers to suitable alternative residential accommodation on reasonable terms.
Thank you. Can I just get something off my chest? Most of these, quite rightly, like you see the next one, Parker, we've actually got a printout of what it looks like on the page. This is what it looks like on the screen, and for someone with my old eyes, it's much more difficult to read. So could those in future putting bundles together always do the PDF, in other words, not a screen printout?
Well, my lord, one sympathises.
Okay. Thank you. However, I'm managing to read it.
Yeah,
so
one has the same problem and peers at these things.
Yeah, but anyway, that's where we are. Thank you. So that was what the duty was.
That was the duty. And if you look in the middle of that page, between the two hole punches, your Lordship will see that Lord Denning said that Miss Morgan applies to the court, from whom there had been a clear argument, and Mr Alan Fletcher, the late Mr Alan Fletcher, appeared for the local authority. The local authority are anxious to know what the legal position is under this new statute. Does it mean that if a person displaced under a housing order, he immediately goes to the top of the queue? Does it mean he's to be treated more favourably than other persons whom they wish to house? And then what the town clerk stated. And then we have Miss Morgan's suggestion at the foot of the page, but we then have what Lord Denning says, that he couldn't accept that submission. I think, he said, the local authority fulfil their duty when they do their best, as soon as practicable, to get him other accommodation.
But you've got to read that in context. He was saying, I must have Rent Act protected tenancy straight away. And the authority had said, no, we'll give you some temporary accommodation now, and when time comes, we'll give you another thing. So he was getting something, but he wasn't getting the Rent Act tenancy. And it's in that context, truly, that Lord Denning says what he says. Not that they don't have to do anything, but they don't have to do the maximum.
Well, he refers, my lord, to their duty. Their duty is set out at the top of the page of the Master of the Rolls' judgment, which we've just seen. And he tells us how that duty is fulfilled. So, whilst it may be the case about the Rent Act protection and so forth for the individual applicant, nonetheless, the Master of the Rolls was undoubtedly putting a broader aspect on this, no doubt in the light of the fact that Mr Fletcher was saying to him, we want to know what the legal position is under this new statute. And he told them what that position was. And then he goes on about the matter, and I don't need to read on. Lord Justice Stamp, over the page, agreed with the Master of the Rolls, page 227, just below the first hole punch, top hole punch, and makes the observation, which he hoped and believed, that every failure on the part of the local authority would not come to be corrected by a mandamus.
That's a different analysis, isn't it? I mean, there's to be no Lord Denning appears to have found that there was no breach of duty.
Yes, and he identified what the duty was.
But Lord Justice Stamp is saying there shouldn't be a mandatory order where there's a failure on the part of a local authority. But on Lord Denning's analysis, there was no failure.
That's absolutely true, my lord. Lord Justice Stamp, of course, said, I agree with what Lord Denning, the Master of the Rolls, has just said, and then went on to make the point which your lordship has just observed. Lord Justice Scarman indicated that the application raised two questions of some importance, and the first was the question of failure to do its duty. The second was the proper case for the court to make an order of mandamus. So he was alert to those two matters to which my lord has just referred, and then he says something about how this was actually a legal right upon the person displaced. And towards the foot of the page, your lordships will see that the Lord Justice observed the duty was that the displaced person would be provided with other accommodation, and he is to be provided with it upon reasonable terms. Pausing there, my lord, in the circumstances with which we're concerned, there's a provision which enables the local authority to secure reasonable terms for any accommodation they provide. And the accommodation must be suitable. He says what suitable indicates. I think the words of on reasonable terms are of great importance, indicating this is his duty to act reasonably. I don't think it necessary in the context of this section to read the word terms as meaning any covenants. I think that the phrase is an indication that the duty to secure accommodation placed upon the local authority is a duty to act reasonably. So this harks back indeed to that discussion about are we only concerned with time or are we concerned with it slightly more broadly.
Yeah, but he's putting it all on the phrase on reasonable terms, which we don't have.
Well, my lord, we have that in the sense of there's a separate provision which says that the local authority, when they provide accommodation, will provide it on terms which are reasonable. And in any event, he...
Sorry, just give me the reference for that.
the reference for that, my lord, is Section 206, subsection 2, page 118, on volume of authorities.
Okay, thank you.
And then he goes on to describe the contrast between, you have a closing order made, and you've got the duty under the Act, and how you could be in an impossible situation, and then about a dozen or so lines, I suppose, down, 4 lines up from the hole punch, can be construed in a manner that puts the local authority into a tolerable position. If one reads the rehousing duty imposed...
Sorry, this does actually illustrate my point.
Yes.
If we had a printout, we'd have the letters in the margin. Where exactly are you reading from?
My lord, can your lordship pick up the number 503, which is immediately...
Well, that's the page number in the report.
Yeah, that's the page number. And then immediately above that, your lordship should see a sentence which begins, but this may be impossible. This is where we've got conflicting statutory duties. Unless
I still haven't found... Oh, I've got it now. Yeah, I've got it now. Yep.
But this may be impossible unless the section in the Act of 73 is construed in a manner that puts the local authority into a tolerable position. If one reads the rehousing duty imposed by section 39 as being to secure that accommodation will be provided which in all the circumstances is reasonable, and I get that from the use of the term upon reasonable terms, then it seems to me that a local authority need not fear that because it has to make a closing order, it may be forced into an obligation of rehousing that it cannot meet.
Then he goes on to say again, he's got some accommodation, it's temporary, and the offer, assuming it's genuine, that they'll be given other temporary accommodation, that the fact that it isn't rent-out protected council accommodation doesn't mean breach of duty. It's a rather different set of circumstances here.
Yeah, and it is... Sorry, I didn't mean to interrupt. It's suitable accommodation, he says.
Yes, it had to be suitable because suitable was written into the legislation in terms of the provision of Section 39 of the Land Compensation Act. My Lord, Lord Justice Lewis is making the point that there were particular circumstances which obtained referable to the Rent Act protection for the displaced person. And I reiterate, if I may, my Lord, the answer which I gave before. The Court of Appeal were invited to consider the duty, so to speak, at large. The background against which it was played out was that, but that, in my respectful submission, doesn't undermine the reasoning of the Court of Appeal in terms of what Lord Denning and Lord Justice Garman, as he then was, had to say. I respectfully say that's an important
but
case.
It's not a duty which allows them to do nothing. There had to be something which was suitable, but not as much as they wanted, it seems to me. And that might be quite analogous to the situation here. They'll get something which is suitable in the short term, but may not be what they want long term. But there's no ability to do nothing. But it's a very differently worded duty anyway.
It was the character of the duty is, in my respectful submission, very similar. Top of page 226, duty to secure accommodation. So that's absolutely, I say, similar. The circumstance in which it might arise would be a different event. Here it happens to be a closure order. But the reference to the duty and how that was to be construed is very much in point when one's considering this type of case. And to go back, if I may, to my Lord Justice Lewis's point about you can do something immediately in performance of your duty by providing whatever it may be. Why should it be the case? One takes here the point that the accommodation is said to be unsuitable. Why should it be the case that one can't perform one's duty by having regard to the present circumstances of the individual there is actually a roof. He has actually been there for a period of time, and say, yes, we perform our duty in a reasonable way, or we perform our duty over a reasonable time, and what that means is he, having the roof above him, will be there for a while until the circumstance of housing in Birmingham enables and provides for something to come forward to meet the needs and aspirations of that individual.
Well, you could have. The problem is you didn't. Your decision was different. You could have decided that, but you didn't.
Well, my lord, the reason why I put that in that terms was to cover off, so to speak, the point which has been made, namely that, well, the judge has decided X in terms of the character of the accommodation. I'm simply saying to your lordships, in support of my proposition as to how these duties can play out and how therefore the duty should be interpreted. Why is it to be supposed that in performance of a duty, attributing reasonableness to the performance of that duty, one can't say, we are going to, in performance of our duty, to allow you to secure that you continue to stay where you are, notwithstanding the labels that are attached to it in terms of suitability. But we notice that it gives you shelter, and that is reasonable, bearing in mind the situation which confronts, in this case, Birmingham, of which your lordships have got evidence, but which is in any event notorious because it's the situation up and down the country.
So your analogy might then be with the village which is flooded, and many of the villagers, their houses are entirely destroyed and they couldn't stay in them, and there would be others whose houses became unsuitable, but they could at a pinch stay in them. You wish to be able to prioritise your housing offer as between those, and you don't see it as being a uniform flat duty to them all.
Yeah, just a duty touched by reasonableness.
Yes. So in other words,
yes.
you're going to deal with the people whose houses where the water reached the bedroom floor first, and those whose gardens and kitchens were invaded may manage to stay for a while until you can get round to them.
Yes.
Even though their housing would, of course, be described as unsuitable within the terms of the statute.
And I'm sure that we can all call to mind individual places and so forth. One doesn't need to have driven far in this country to realise that there are many places touched by the hand of floods, Upton-upon-Severn and so forth, where that sort of circumstance may occur. And so all we're saying is, please allow for, in terms of the exercise of the power under this duty, the sanction of reasonableness rather than the immediacy and the denial of a reasonable period of time to go back to the terms of the declaration. So, my lords, that is the case of Hendy, and it was regarded as applicable to this class of case, and I simply make a passing reference here to authority number 22, where the headnote records it at page 294R against the London Borough of Brent, a housing case. Now, there are two pairs of cases which I say support our position, and where your lordships are going to have closely to consider what actually is the ratio of those cases, what were the determining features of them. This pair is, on the one hand, Cadona and Ali, which also travels under other names, and on the other hand, Sheridan and Slattery. They're all in this court of appeal. Oh, they're all in this court except for Ali, which went to the Supreme Court. Now, the proposition which I take from the first pair, and in particular from Cadona, is that one has a reasonable time to fulfill the duty under 1932. Cadona is in the second bundle of authorities at flag 36.
Do you mind, before we go to Sheridan and Slattery, just telling us what the proposition there is for Sheridan and Slattery, the second?
Oh, the proposition for Sheridan and Slattery is that those cases confirm the position taken and that I have derived from Cadona. Right. So they are confirmatory. That's the proposition which I take from them.
Thank you.
And as I say, Cadona is the second volume of authorities, flag 36. And this was quoted at length by the judge below. And your lordships will see that at paragraph 21 on page 476, the law is stated by Lord Justice Auld, who gave the judgment with which Lord Justice Thomas and Mr Justice Holman agreed, and he did that by way of an amalgam of those provisions which he there mentions, and then he describes what was happening, the situation in the Cadona case, being that someone who occupied a caravan on a pitch wanted another pitch on which he could put his caravan. If your lordships turn on, you will get to 479, paragraph 33, where the learned judge records that the authorities suggest a number of basic propositions for the criteria of suitability of accommodation for offer to, and then he goes through those and arrives at fourth, paragraph 38, where it is shown that a local housing authority has been doing all that it could. The court would not make an order to force it to do the impossible. And then he speaks as to its duty. Its duty was to secure the availability of suitable accommodation within a reasonable period of time. The reasonableness of that period depending upon the circumstances of each case and on what accommodation was available. So in that paragraph, he is drawing from the authorities and stating as a basic proposition two matters, I would say. The point about you won't make an order to force the impossible, and separate from that, what the duty is within a reasonable period of time.
You're obviously right as a matter of language that he's in separate sentences dealing with the question of whether you will order mandamus and the question of whether there's a duty. But with all respect to Lord Justice Auld, it might be thought he's not really clearly distinguishing between them in his mind, because the examples he goes on to give in supporting those propositions is really puts it in terms of mandamus, doesn't it? Because he quotes from from Bagram, where Mr Justice Collins said, Parliament has not qualified the duty in any way it could have done, so pausing there, you've got to do it straight away. However, the situation with council is not quite as desperate as it might be. While the duty exists, no court will enforce it unreasonably. So it's saying there is a duty, you are in breach of it, but we won't make an order in such cases. Now, Lord Justice Old quotes that passage as supporting what he's said in the text before, but in fact it really only supports the mandamus point, doesn't it?
The text from Mr Justice Collins is particularly referable to the question of mandamus. There's no doubt about that. One can't escape from that proposition. And one can readily acknowledge, if one's permitted to say this with the greatest respect, that it could have been stated better. But nonetheless, it's perfectly apparent on the language, separate sentence, that there were these two matters distinguished, that is to say, what order and what is the duty.
That gives rise to this problem, doesn't it? Because of the way that later cases, Lady Justice Harding, for example, has dealt with it, this may be one of those rare cases where it's actually important to identify whether it was part of the ratio decidendi, a necessary step in the reasoning. And the issue at paragraph 27 and earlier is whether, when you're dealing with gypsies, judicial gypsies, is it an appropriate discharge of the duty to offer bricks and mortar accommodation rather than somewhere where they can put the caravan because they're nomadic. And if that's the issue, although Lord Justice Old has said that the authority suggests a number of basic propositions, it doesn't seem to be part of the ratio decidendi. Or is it?
No, my lord, if one takes it in that narrow way, I would say that there is some strength in what your lordship suggests. But I suggest, if I may, that one shouldn't take it in that particular way. And for that purpose, if your lordship would go back to page 471 and the head note, your lordship will see that the editor of the Housing Law Reports records in the head note against H22 that in deciding the question of suitability, you've got to give special consideration. And then in considering by an authority whether the accommodation offered is suitable, they must examine carefully his claim for special consideration. And then when their authority are considering whether a refusal by a gypsy of an offer of bricks and mortar is genuine because of a claimed aversion, they have to take into account the following matters. And then having regard to the reasonable assumption that the appellant would only be in bricks and mortar for a short time, the decision that the accommodation offered to the appellant was suitable did not violate her rights under Articles 8 and 14.
Well, insofar, I mean, we're not bound by how the editor analyses it, but that support my lord's analysis rather than yours, because there's nothing in this summary of the ratio, which you've just helpfully taken us through, the holding, which actually picks up on para 38, or am I missing something?
On the duty to secure the availability of suitable accommodation within a reasonable period of time. Well, I would just hark back, if I may, which is why I did that exercise in terms of the head note in response to my lord's observation, that if one looks at 3 and 4 in particular, the aspects being considered were that suitable accommodation would come to be placed before the applicant in due time. Consequently, it was clear that it was necessary to consider what that duty was, because if the position were one whereby the securing the availability of suitable accommodation required the pitch to be provided upon which the caravan could be placed, then one is full square, I suggest, within the question of what actually is the duty.
If you look at 60,
I beg your pardon, my lord?
if you look at paragraph 60, depending on the quality of the bed and breakfast accommodation offered, and on the reasonable assumption that the council will see to it that their stay there will only be for a short time, the council has so far discharged its statutory duty. So it's the provision of accommodation, albeit temporary, which discharges the duty, and that doesn't violate Article 8 and the right to respect for private life. But there's nothing to say that the duty, the content of the duty was they didn't have to provide anything for a reasonable period of time, or that the duty was to be expressed in content as within a reasonable period of time. And if you look at paragraph 2 and 3, it just doesn't seem to be what the case was decided.
Oh, well, my lord, if your lordship will forgive me, if you hark to paragraph 60, the council has so far discharged its statutory duty, and that was referable to what has been provided. And now, if that is so, then what is being said in the context of that case is quite plain, that the duty is being performed reasonably by taking those steps, and reasonable performance of that duty is what is required by its terms and not otherwise. So I would answer the question as to the ratio that, one, it is important to seek to establish what it is, but two, when one does, it was important and necessary to the reasoning of the learned judge and the Court of Appeal as to consideration of the terms of the duty in the way I've just described.
Yes, so that's Tredena, is it?
And could you go back, please, to 29 in the Lordship will see that Mr Watkinson put his grounds in a particular way, and the fourth was just above line 30, that in any event no evidence the council had done all that it could have done to obtain a site or use its statutory powers to assist it in doing so.
So is it your submission that this is binding upon us as authority for the fact that you have a reasonable period of time to fulfil your 193 duty, or are you bringing it to our attention as showing that it's consistent with that proposition?
I would say that it's binding on your lordships in support of the proposition that the duty is one to be exercised reasonably. Because I just don't want you to take it further than I need or properly can take it, given its terms and given the discussion with my Lord Justice Lewis.
That doesn't help though, because exercise reasonably, I'm still puzzled as to whether the reason why there was not a breach of the duty was because they'd provided something, bed and breakfast, or whether or not they provided bed and breakfast, they didn't have to provide a caravan site without a reasonable period of time having elapsed.
Well, my Lord,
Did you follow me?
I do follow your Lordship. I would say that it's plain that it was clear that there was no immediacy in terms of the provision of the site upon which a caravan could be placed. And so in terms of temporal considerations, there was that reasonable time as far as that is concerned. And that sits with the question of the duty being exercised and being touched by the point of reasonableness generally because of what happened prior to the potential provision of that site upon which the caravan was going to be
So
sit.
would they be in breach of duty or not if they hadn't provided the bed and breakfast?
The answer to that question is they may have been in breach of that duty if the position was one whereby a reasonable exercise of that duty would have secured that elementary cover of bed and breakfast for the applicants in question. In other words, your lordship would, in that circumstance, be concerned with an authority which was sitting on its hands, which has been described in one or other of the cases as an indicator of when it would be that the court would intervene. But if the local authority, the local housing authority, is not sitting on its hands, the court, in my submission, does not intervene. Now, my lords, Cadona was, as your lordships know, referred to in the Ali case, which your lordship has reports, first instance, Court of Appeal and the Supreme Court. The Supreme Court is flag 39 in volume 2. And the proposition that I take from this case is that the Supreme Court, it was the House of Lords, I do beg your lordship's pardon, the House of Lords made plain that Lord Justice Old was correct when he indicated that the duty, interpreted in context, provided for a reasonable period of time. Now this is flag 39, and if your lordships could go first to Lord Hope, and I will just make, in passing if I may, as we're here, the point I referred to earlier about Scotland, which is paragraph 3, your lordships see that on page 540, which is the point about the language being the same, even though there's been a slight change as between 3 acts. Now, my lord, Lord Hope records in the usual way, I suppose, that he read everything else, and then the question which lies at the heart, he says, of the Birmingham case is whether it's a lawful discharge.
So where are you now reading
I'm reading
from?
paragraph 2 of the...
Right. Okay, got it, yes.
Page 539. The question which lies at the heart is whether it's a lawful discharge of the duty under 1932 to leave a family in accommodation which requires them to be treated as homeless under 1753 because it's accommodation which it's not reasonable to expect them to continue to occupy. And your lordships will remember I made the observation earlier on about there's this concept of reasonableness of continuing to occupy, and then also the concept of suitability. I don't need to trouble about the Manchester case. And then paragraph 3, his lordship says that he wants to associate himself particularly with observations about certain sections looking to the future as well as the present. And I would make the same point, he says, about the duty in 1932, which requires the housing authority to secure that accommodation is available for occupation by the applicant. In Cadona, against letter C, Lord Justice Old said the duty of the authority was to secure the availability of suitable accommodation within a reasonable period of time, the reasonableness of the period depending on the circumstances of each case and on what accommodation was available. Mr Justice Collins took a different approach. He said it was a breach of the authority's duty for it to require families to remain in unsuitable accommodation even for a short time. I prefer the approach which Lord Justice Old adopted, but Mr Justice Collins recommended discussion leading to agreement, not compulsion. And then the point about Lady Justice Arden disagreeing with the way the duty was expressed. She said, I don't read on, but the words of the subsection need to be seen in their overall context.
Where are you reading that from?
Just below the head.
Yeah, got it, yes. Yep.
The urgency of the action that is needed will vary from case to case, including the way the authority fulfills its interim duty under 1881. Each of these two duties needs to be seen in the light of what can be done in the performance of the other. There may be cases where it would not be unreasonable for a homeless person to be expected to continue to occupy for a short period, accommodation which it would not be reasonable for him to occupy for a long time, while the authority looks for accommodation which will release it from its duty under 1932. I agree with Baroness Hale that the court must have regard to the practicalities of the situation. As Lord Justice Old in Cordona said, the court won't make an order to force a local authority to do the impossible. And then, skipping a sentence, the point I wish to stress is that the description of the duty in Cordona is, with respect, the one which should be adopted in preference to that recommended by Lady Justice Arden. And Lord Scott expresses, top of page 541, agreement with the views of Lord Hope in paragraphs 3 and 4, which we've just read.
Could before we go on with this, could we just situate ourselves in the facts of the first appeal in that case, which are in the head note at 536? Is it your submission that the 6 cases that were the subject of the first appeal are on, forgive me, on all fours with the facts of our cases, or that there are differences of which we should be aware?
My Lord, I trust your Lordship won't think I'm avoiding your Lordship's question, but I want to make sure that I give a completely accurate answer to it, and so I would wish to come back to that if I may, because I know that I will get assistance in answering that question over the short adjournment from those around me.
I will. Thank you.
I'm much obliged. Now, my Lord, Baroness Hale deals with the matter starting at page 548, paragraph 34, and then she makes the point at 36 about the language, and here she's referring to sections 175 and 191, and looking to the future as well as to the present, and so that's what Lord Hope picked up on.
So sorry, where
That's the foot of the page, 548, my Lord.
yes.
And then she continues to say, top of the page 549, they both use the words continue to. This suggests that they're looking at occupation over time. This suggestion is reinforced by the words would be and would have been. These again suggest an element of looking to the future as well as to the present. They contrast with 177(1), which provides it is not reasonable to continue to occupy accommodation where there's a risk of violence. These linguistic reasons are reinforced by the policy of the Act, and I don't need to read that. In the Birmingham case, this interpretation has the advantage.
Sorry, just help me. Which was where do we find section 1753 set out?
Oh, you'll find that in volume 1.
No, it'll be in the report, won't it?
Oh, I beg your pardon, my lord. I'm so sorry.
It's paragraph 16.
Yes.
Yes, thank you.
paragraph,
Yep.
yeah.
Okay,
Page
thank you.
5-4.
Yes,
really
I have it.
running
Thank you.
into-
No, I have it now. Thank you. Yes, do go on. Sorry.
And then, Birmingham case, this interpretation has the advantage that the council can accept that a family is homeless, even though they can actually get by where they are for a little while longer. The council can begin the hunt for more suitable accommodation for them. Otherwise, the council would have to reject the application until the family couldn't stay there any longer. The likely result would be that, and I don't read on there. And then if one looks at page 42, paragraph 42, page 550, she has now moved to the duty under section 193, into which she says the preceding text feeds. And at paragraph 42, given that an authority can satisfy their full housing duty by providing temporary accommodation, which must of course be followed by the provision of further accommodation so long as the duty survives, these observations clearly do not only apply to 188. They emphasise that accommodation which may be unreasonable for a person to occupy for a long period may be reasonable for him to occupy for a short period. Accordingly, there will be cases where an applicant occupies accommodation which it would not be reasonable for him to continue to occupy on a relatively long-term basis, which he would have to do if the authority didn't accept him as homeless, but it would not be unreasonable to expect him to continue to occupy for a short period while the authority investigates his application and rights. And at 47, page 551.
Well, surely you've not emphasised, you've not read us the bit which is most important to your submission.
I'm so sorry.
Even thereafter, while they look for accommodation
Yes.
to satisfy their continuing section 1. That's the bit that matters. Yeah.
Well, I emphasise that, and I was next going to go to 47.
But that looks to me as if they're accepting that there has to be, if you like, an immediate provision of something, but it's really something to get them by, whilst they look for, in inverted commas, more suitable accommodation. So it's not saying they don't have to do anything immediately. They've got a reasonable period of time before they do anything. This seems to be saying the duty, the composite duty, touched, as you put it, by reasonableness, something to tide them over, and the hunt for the perfect house later.
Yes.
But
I mean, the phrase
nothing.
more suitable, so sorry, the intellectual excitement that's involved with it. The phrase more suitable, which we get in 38, I mean, it's Lady Hale speaking in an accessible language,
Yes.
but in fact, under the Act, suitable is binary. Something's either suitable or it isn't. But that looks as though what she means is that she accepted this was suitable accommodation in the short term, but wouldn't be in the long term.
That is a way in which it can be looked at, because suitability embraces temporal considerations as well as other physical considerations. And where we get to, as far as this matter is concerned, is that what is abundantly clear from what Lady Hale is saying is that 193(2) operates, if I can put it this way, on a temporal basis, and furthermore, that it operates in a way which is one whereby what is reasonable will vary according to the circumstances, but which the duty which is being performed is one to be exercised reasonably, to include the passage of time.
Well, but it does, doesn't it? But how does it do that? Does it do that by saying you can leave people in unsuitable accommodation for a bit, as long as you're going to put them into suitable accommodation at the end, which is your submission, has to be your submission? Or does it mean you accommodate the passage of time by saying that as long as you put them in accommodation which isn't too bad for a bit, that will count as suitable, as long as you're going to put them in more suitable accommodation later? And I'm bound to say that Lady Hale, though not Lord Hope, appears to be taking the latter approach, i.e. one which doesn't support your case.
Well, I would tend to agree with the proposition that Lady Hale is using the question of suitability in quite an expansive way to enable it to be said that of a particular circumstance which might otherwise stand to be condemned, because it's only for a short space of time, it's to be regarded as suitable, and therefore one doesn't need to worry about the fact that accommodation that has been provided would otherwise be labelled unsuitable. The question which then arises is what happens in the circumstance where you say, well, never mind the temporal consideration. The position is one whereby you've still got a roof over your head, you are still protected against the elements, and the fact is that we can't provide you with anything at the moment, but we will come to do so. Can one reasonably perform one's duty in that way? I say you can, because one, there's no other way in which it works, and two, because the proper construction of the provision should embrace reasonableness rather than unreasonableness. And if that's...
Doesn't it do that by having a gradated concept? Or I quite accept it. We've got to construe this in a way that produces a reasonable outcome for local authorities.
Yeah.
But don't you do that by allowing degrees of suitableness affected by how long you had to put up with them for?
Well,
so this property will be suitable for you in the short term, but not in the long term. And that's what I get out of Lady Hale.
Well, my lord, Lady Hale, as I've accepted, was going along that particular path. I can't avoid that proposition that she was going along that particular path. But undoubtedly she allowed time for fulfilment of the duty under 1932. Whether in consequence of going along that particular path or otherwise, in my respectful submission, doesn't much matter because she was...
Doesn't it matter crucially? It's the fundamental point in the case. Because you here have accepted this property wasn't suitable. These properties, you might have said, or at any rate you've been found by the judge to have accepted these properties weren't suitable. You could have said they're suitable in the short term. But you didn't go down the Lady Hale route, so you have to take the more absolute route. But in terms of... So that's why it is the most important point in the case, isn't it? Or am I missing something?
No, your lordship's not missing anything at all in my respectful submission, because the fact of the circumstances is that suitability is being given by Lady Hale and by others an elastic meaning to cover the circumstances described by the passage of time.
In those cases, on a quick reading of the head note, except in one case, the applicants for housing had been some months. I think there's one case where it was years, but in general, when we're considering short-term and long-term, the statements were made in the context of much shorter periods of time than obtained in this case.
My lord, that's right. I mean, the periods of time in all these cases is variable, and some of them are really quite long periods of time, as your lordship has observed.
But when one looking at paragraph 42 in short and long periods, one has to have a mind to what the periods were in the case that was then in question.
Yes, it becomes very difficult, I would say, to transfer from one case a period of time and then say that in another set of circumstances, possibly involving a different authority, that the same period of time categorises as reasonable or unreasonable.
I quite understand that. It's just that I don't think there's any support for the idea that a reasonable period of time, as seen through the alley lens, amounts to years.
Yes, I mean, one couldn't identify from the alley lens a period of time and get out one's diary and say that will end on such and such a date. One couldn't do that. What one can see from the alley case is not merely what obviously Lord Hope and Lord Scott said, but also that Baroness Hale was at pains to point out, see paragraph 49, that it could be, this is top of page 552, it could be that in some or conceivably all, a critical examination of the facts would establish that the Council were at some point in breach of their duty under Part 7 of the 1996 Act. In other words, she's allowing for a period of time and saying a critical examination may lead to that circumstance. She goes on to say in that paragraph that the Council were entitled in principle to leave the families in their current accommodation for a period, notwithstanding that it was accepted.
I'm referring to 47 and 48. 47, not indefinitely. 48, for a little while. First sentences of each. It just sets up the observations that have been made in 49.
My lord, it does, and I can't, as I say your lordship could get a diary out and say...
You say this is authority for the fact that it doesn't mean right now no flexibility. That's all you need it for.
Yeah, absolutely, my lord. Absolutely right. And as soon as I've got that, frankly, the position is secured as far as the City Council...
As far as Ground 1 is concerned.
Well, is it? I'm sorry. This is crucial. I may be missing it. The position isn't secured, is it? They were entitled to leave these people where they were indefinitely, but that was on the basis... Sorry, I'll start again. They were entitled to leave them where they were for a little while, in principle. But that was on the basis that for a little while those properties would continue to be suitable, which is a finding that's not open to you in this case. That's I'm sorry if I'm banging on about a point, but when you say, oh, well, if you get that far, you're home, you're not home because you've got to find the basis on which she said that. Am I making myself clear?
Your lordship is making yourself perfectly... So sorry.
It's implicit in her finding that there was a period of time when they had something, and that was all right short term. It's not a case of does not mean right now. It means something more nuanced. It's okay right now in the circumstances. It wouldn't be all right forever.
Well, I'm not sure about that if one looks at 49. I appreciate that it's being looked at through not reasonable to continue to occupy. But that suggests in the middle of paragraph 49 letter B that we're going forward on the basis that short time in unreasonable premises.
Well, I think that I respectfully agree, my lord, but the vehicle she uses for that conclusion appears to be that unreasonable premises may nevertheless be suitable accommodation for a short time. If you look at the end of 48, the way she puts it there is there was bound to come a time when their accommodation could no longer be described as suitable in the discharge of the duty under section 1932. I think there it's not really implicit but explicit that what she's saying is that the reason why the council wasn't in breach was that the mere fact that this was not property which it was reasonable for them to occupy, 1753, was nevertheless, it could nevertheless be suitable for a short time. And then she goes on to make the point that if they put their case a different way, they might well have won on that, but they didn't.
My Lord, paragraph 48 obviously has the characteristic which your Lordship has just described, and one can bear in mind at paragraph 50 that, having referred to what happened before Mr Justice Collins in the Court of Appeal, the Baroness says it's right to face up to the practical implications as the approach to be adopted by a court when considering the question whether a local housing authority have left an applicant who occupies accommodation which would not be reasonable for continue to occupy that accommodation for too long a period. The question is, of course, primarily one for the authority, and a court should normally be slow to accept that the authority have left an applicant in his unsatisfactory accommodation too long. In Birmingham, there are many families in unsatisfactory accommodation, and then she refers to certain the matters. Wrong to ignore those pressures, and your Lordships may have noticed that in the recital of the facts in the Birmingham cases, at paragraph 24, Lady Hale refers to the applicant's, paragraph 24, having been provided with accommodation, but later accepted this was not suitable for them. And then I don't need to read on.
Sorry, I may I just look at that? You may not, but I...
Paragraph 24, page 546, my Lord. In two cases, provided with accommodation, later accepted not suitable, and then the council accepted after a period of time.
But surely that's part of the earlier history.
Yeah.
That's not the property they were in at the time of the dispute, is it? Well, there. Well,
yeah.
I see the time,
Well, beg your
but
pardon.
you read us paragraph 50. One, of course, has to read paragraph 51 as well.
Of course, my Lord.
But yes. Well, there we are.
Yes, I mean, your Lordships have a question, which is, your Lordships have got two members of the House of Lords being absolutely express about a particular matter, seemingly in agreement, as they put it, with Lady Hale. Lady Hale not expressing any form of dissent from the propositions which they had advanced, so obviously she would have known what they were going to say. And then the position where one's got the Court of Appeal saying this is the circumstances we've seen in the judgment of Lord Justice.
Well, we haven't looked at the Court of Appeal yet, or unless you're talking about Cardona.
I was talking about Lord Justice Alder.
Oh, I see.
We've got the Slattery and Sheridan cases to come.
Yes.
They're very quick.
Right. Well, nevertheless, we will deal with them after lunch.
And much obliged.
I mean, this is the hard pounding part of the case, so you're still confident that you'll be finishing, hopefully, before the end of the day.
Well, my Lord, I want to try and stick to what I said.
Yeah,
And
well,
I want to gain that brownie point if there's a brownie point.
Well, I assure you it's
on
going.
offer.
I'm sure it's going. What form it'll take, I don't know, but there will be some reward, I'm sure. Right. 2 o'clock.
Obliged.